Your most private conversations are being watched. And one wrong word, taken out of context, could lead to this.
How could a private conversation lead to a police visit? It starts with something millions of us now do every day. We turn to AI. It's become our digital confessional, a private sounding board for our most sensitive thoughts.
But this perceived privacy is an illusion. The digital confessional has a watcher.
Escalate to law enforcement.
That terrifying scene isn't fiction. It's the potential reality of a policy that turns your AI assistant into a potential informant. Companies like OpenAI have implemented systems that actively monitor your conversations for imminent threats of physical harm. If their AI classifier flags something, it gets sent to a human review team that has the authority to contact the police. But what defines physical harm?
OpenAI is reporting chats?
My privacy is gone!
Is anyone safe?
When this policy became public, the backlash was immediate. Users felt betrayed, realizing their private chats were never truly private. This creates a fundamental conflict: the pressure on platforms to prevent harm versus your fundamental right to privacy.
How is this legal? The justification rests on a law written on this was state of the art. The Electronic Communications Privacy Act of 1986, or ECPA. It has an emergency disclosure exception that allows a company to share your data with police without a warrant if they have a good faith belief that there's an emergency involving danger of death or serious physical injury. The key is good faith. The company doesn't have to be right. They just have to reasonably believe there's a threat. But what about your Fourth Amendment right to privacy? For decades, the courts followed the third-party doctrine. If you voluntarily give your data to a company, you lose your privacy rights for that data. But in 2018, the Supreme Court case Carpenter versus United States challenged that idea for the modern age, ruling that highly sensitive digital data, like your phone's location history, deserves protection. Your AI chat history, which can reveal your innermost thoughts, falls squarely into this unresolved legal gray area. And this brings us to the biggest risk, the false positive nightmare. This is when the AI or a human gets it wrong. Imagine a different scenario. A history student is researching the radical movements of the 1970s for a term paper. She asks the AI detailed, hypothetical questions to understand their ideology. She's doing her homework, but the algorithm doesn't see a student. It sees keywords. That is the danger of this system. A technological mistake becomes a real-world trauma, all because the context of your conversation was lost in translation. There is no perfect answer here. It's a direct trade-off between privacy and safety. So what can be done? The path forward focuses on two key ideas. First, mandatory transparency reporting. Civil liberties groups are pushing for laws that would require AI companies to publish regular reports detailing how many chats are flagged, how many are sent to police, and, crucially, the estimated false positive rate. Second, clear user-centric controls. Instead of burying these policies in fine print, companies must provide clear, unavoidable notice. In Europe, the new EU AI Act is already doing this, creating a comprehensive, rights-based framework that classifies these systems as high risk and impose strict rules on them, a stark contrast to the patchwork of old laws in the US. The policy to monitor our private chats is more than just a corporate decision. It's shaping the social contract of our digital future.
The legal framework, built for a world of letters and landlines, is straining to keep up.
Don't let others decide the future of your privacy. Share this video with someone who believes their conversations with AI are completely private. And now I want to hear from you. What is the right balance between privacy and safety? Let me know in the comments.